I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Another big win for special counsel Jack Smith in his criminal investigations of Donald Trump. This win was before the D.C. Circuit Court of Appeals, which denied Donald Trump's appeal from a lower court's order, which rejected Donald Trump's assertion of executive privilege, whereby Donald Trump was asserting executive privilege to try to block the testimony of some of his former top advisors. And let me give you a list of who some of these former top advisors are who have now been definitively compelled to testify before the criminal grand jury in Washington, D.C. when Donald Trump was trying to block their testimony. We're talking about Donald Trump's former chief of staff, Mark Meadows. We're talking about the former director of national intelligence, John Ratcliffe. We're talking about the former national security advisor, Robert O'Brien. We're talking about the former top aide, Stephen Miller. We're talking about the former deputy chief of staff and social media director, Dan Scavino. We're also talking about former top aide, Nick Luna, former top aide, John McKinty, and former top DHS official, Ken Cuccinelli. And so here's the sequence of events that took place. Special counsel Jack Smith sent subpoenas from these criminal grand juries to each of those individuals, compelling them to testify before the grand jury, to produce documents, records, text messages, emails, everything in their custody and control, and also to testify before the grand jury. These people that I just listed either objected in part or objected in whole to giving their testimony, meaning some showed up and gave a little bit of testimony and others just didn't testify at all, claiming that Donald Trump had asserted executive privilege, and they claimed that they were blocked from testifying before the grand juries about what took place, about their communications with Donald Trump, until such time as there was a court order compelling them to actually testify, at which case they may either invoke their Fifth Amendment rights against self-incrimination, they may then testify, and if they invoke their Fifth Amendment rights against self-incrimination, the Department of Justice can then determine if they are going to grant them what's called a transactional derivative use immunity here for the purpose of just immunizing their testimony, at which point they can no longer assert their Fifth Amendment rights against self-incrimination. And so that's what was taking place in the grand jury room. So then special counsel Jack Smith went and filed motions to compel their testimony. Judge Beryl Howell, who was the former chief judge who presides over or previously presided over all of the criminal grand juries in Washington, D.C., she ruled executive privilege didn't apply. Donald Trump went on TV and claimed, one of these right-wing propaganda networks, and claimed he had nothing to hide. He wasn't going to appeal anything. I think it was Newsmax. And then Donald Trump, of course, lied. And then he filed an appeal last week. We covered his appeal last week here on the MeidasTouch Network. We told you our view that we believe the appeal was frivolous and he was going to lose before the Court of Appeals panel. And here we have in a per curiam decision, let's pull up the decision right now. Donald Trump's appeal was denied. This was per curiam, meaning the entire panel. It was a unanimous decision. That's what that means. Let's pull up the order. You see the case name, in re sealed case. It's called that because all grand jury proceedings are under seal. So you don't get to actually see what the filings are, but you can, see what the order says. You don't read the filings because the filings are under seal, but you can deduce what's taken place based on what's on the docket. And here's what it says. Per curiam order filed considering the emergency motion, the opposition and reply, denying the emergency motion before Judges Millett, Wilkins, and Katsas. And so this three-judge panel per curiam unanimous ruling denied Donald Trump's assertion of executive privilege. Let me just remind you what executive privilege is. Executive privilege is a way to shield or not disclose communications in general, if a privilege exists. So we've talked about attorney-client privilege. There's other privileges privileges called doctor-patient privilege. But privileges are not absolute, or some privileges are not absolute, and all privileges aren't created equally, so there are exceptions to privilege, right? When it comes to the attorney-client privilege, there's what's called the crime-fraud exception. If Donald Trump is using his lawyers to actively commit new crimes, then Donald Trump can claim, I have a privilege in my communications with my lawyer are confidential. And we saw special counsel Jack Smith also prevail before the federal courts in Washington, D.C. on that argument as well. That was in connection with Donald Trump's theft of thousands of government records and his obstruction of justice, right? Special counsel Jack Smith proved that Donald Trump was using his lawyer, Evan Corcoran, in furtherance of obstruction of justice. And therefore, the federal judges compelled that their communications be produced, whereas otherwise they would not be able to be disclosed. Now, similarly, executive privilege is a type of privilege where information would not be disclosed, and it involves a different type of fact pattern where it is communications between a president and their staff and their aides and people who they rely on for advice. The reason that you have this doctrine of executive privilege is because the law says, look, in normal course, we want presidents to feel that they have discretion and that their communications are confidential. Otherwise, you'd have the media and everybody trying to subpoena it, and a president would be chilled and not have the ability to engage in the forthcoming communications that an executive would otherwise want to engage in, or that they should otherwise engage in. However, there are exceptions to executive privilege. One of the exceptions to executive privilege is the fact that in mostly all circumstances, a former president, a former executive can't assert executive privilege. There is a narrow circumstance where a former executive may be able to assert executive privilege, and that is as it relates to an interbranch dispute, although that line of case law has not been fully fleshed out. But certainly, a former executive is almost certainly not able to assert executive privilege against a new executive branch, against the current executive branch, where the current executive branch is not asserting the same privilege. And here, the Biden administration is not asserting executive privilege on the grounds that the January 6th insurrection was certainly not in furtherance of any executive function. It was not in furtherance of any constitutional duties. Quite the contrary. Donald Trump's conduct on January 6th was to overthrow our Constitution, to overthrow our democracy. So Biden did not assert executive privilege. So Donald Trump should lose on that basis alone. However, there's another grounds also that the Department of Justice would also argue, and that is what's called a compelling need or compelling interest test. And if the Department of Justice can show the court that there is a compelling interest in their investigation, that can override the privilege being asserted, in this case, executive privilege that is being asserted. And that's specifically unique to executive privilege. And here, that's another argument that the Department of Justice made, that there is a compelling need, a compelling interest in the fact that they are engaged in a criminal investigation. And it's especially compelling because it's an investigation that involves Donald Trump trying to overthrow our democracy. And of course, the events on January 6th, trying to stop a free and fair election and trying to investigate that, is a compelling need. So for those two independent reasons, I was always very confident, and that's what I had told everybody here at the MeidasTouch Network, all of the viewers, that I was confident Donald Trump was going to lose at every step when you apply those legal tests. And sure enough, Donald Trump did lose here, and did lose big, with this federal appeals court panel rejecting Trump's bid to block his top aides from testifying before the grand jury. Special counsel Jack Smith will now get to cross-examine them. This is big news, folks. And again, let me just go through the name of those witnesses with you. We're talking about Mark Meadows. We're talking about former Director of National Intelligence John Ratcliffe. We're talking about former National Security Advisor Robert O'Brien. We're talking about former top aide Stephen Miller. We're talking about former Deputy Chief of Staff and Social Media Director Dan Scavino, former aide Nick Luna, former aide John McKinty, and former top DHS official Ken Cuccinelli. Folks, the wheels of justice turn in the right direction. Big win for Special Counsel Jack Smith here. These witnesses will be required to testify. They'll be required to testify and turn over records soon. This is a very, very, very good order for justice. Things are moving in the right direction there. Until next time, I'm Ben Meiselas from the MeidasTouch Network. Please hit subscribe. We're on our way to 1 million subscribers, actually 1.5 million subscribers. We just passed 1 million. I keep forgetting. 1.5 million subscribers. Also, check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. In addition to Patreon, subscribe to the MeidasTouch podcast. It's free. Just search MeidasTouch podcast. And yeah, hit subscribe right now in this video. It's free. Thanks so much for watching. Until next time, I'm Ben Meiselas.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.